hear ye. The Honorable Court of Appeals of the State of Oregon is now in session.
Good morning, please be seated. We have 4 cases we'll hear this morning. The first is A180204, State versus Cranston. We're ready for your argument when you're ready.
Good morning. Thank you, Your Honor. May it please the court, counsel Lindsay Burrows for defendant Ian Cranston. I intend to focus my limited time this morning on the first assignment of error regarding the duty to retreat instruction, or actually the lack of duty to retreat under Oregon law. I do think, though, that the Chitwood argument is strong and presents serious prosecutorial misconduct in this case. Obviously, this court has had plenty of opportunities to interpret Chitwood at this point. I'm more than happy to answer any questions that the court has regarding those issues. Because again, I think this case presents very serious prosecutorial misconduct that on its own warrants reversal, even in a plain error posture. But turning to the lack of duty to retreat, the trial court erred by refusing to give defendants requested instruction. The instruction was a correct statement of law, and it was needed to cover a necessary point of law that the uniform instructions did not otherwise address. The instruction was also necessary to prevent a risk of jury confusion in light of the state's evidence presented at trial, and then the way the state used that evidence in closing argument to specifically suggest that because there were other alternatives available, self-defense was unavailable to defendant.
Can you work us through the instruction in terms of what was requested, what the trial court gave, and then Sandoval and how it fits together?
Yes, certainly, Your Honor. So the requested instruction was Oregon law does not impose a duty to retreat before a person can use deadly force in self-defense or in defense of another person. So the idea behind the instruction, the plain sort of text of the instruction, is that if the jury finds an alternative besides the use of force, that is not a basis for rejecting self-defense on its own. But the court also gave all of the uniform instructions on self-defense, which defendant requested, and those included the requirement under Oregon law that the state disprove beyond a reasonable doubt that the threat was imminent. And I think that is where the state's focus is. And that concern was squarely addressed by the uniform instruction that was requested and given. The trial court declined to give the instruction, reasoning essentially that there is a duty to retreat under Oregon law, which is plainly inconsistent with Sandoval. We can talk about that. And the court said that the jury could use whether there were alternatives available in the reasonableness of the self-defense calculation, which is exactly what Sandoval teaches is the wrong way to use this sort of evidence.
Doesn't the state say the proffered instruction was inconsistent with Sandoval? And so why is that not? Why aren't they right about that?
Right. So I think, Sandoval stands for the clear proposition that as a matter of law in Oregon, the legislature intended that a person be able to use force to meet a threat of force. That is in the deadly force context and in the non-deadly force context. And in Sandoval, I think the language of the opinion couldn't be clearer. The court says nothing in the wording of the self-defense statute, so the court actually cites the statutes, just paraphrasing that part, suggests that persons who reasonably believe that another person is about to use deadly force against them must calculate whether it is possible to retreat from that threat before they use deadly force in self-defense. That's on page 512. So again, that is exactly what the defense counsel is asking the jury be instructed. And because the prosecutor inserted sort of the alternatives that were available, couldn't you have just walked away, Mr. Cranston? That became a hotly contested issue in the case and made the supplemental requested instruction necessary.
And there was a video and they played it several times, is that right?
Yes, Your Honor.
And counted seconds and things like that?
Yes, right. So, right, there was a video. Was it, the clearest video? I think defendants, and when evaluating this sort of assignment of error, the court views the evidence in the light most favorable to the party who requested the instruction. Defendant testified that when he ultimately fired the gun, BW, the alleged victim, was at that moment about to swing and punch him again, as BW had done multiple times, had also punched Mr. Cranston's friend, and shoved, or there was some dispute, but in the light most favorable to defendant, his fiance as well. So this is an active threat situation. And what the Supreme Court case law teaches is that the legislature did not want someone to have to run through the list of possible alternatives when faced with a threat of serious physical injury or deadly force, which is exactly this circumstance.
So we're just refresh my memory. So the state says that, again, the instruction failed to capture the distinction between imminent and non-imminent threats. In the end, giving the instruction would have confused the jury. Why aren't they right about that?
Right, because
I wondered about it.
Yeah, thank you, Your Honor. Because imminence was always going to be required, and the jury was instructed that there had to be an imminent risk of serious physical injury constituting a felony or deadly force to defendant in order for self-defense to apply in the first place. So what was missing from that imminence was required, there's no dispute. But what was missing from that is that if the jury did find that there was an imminent risk of serious physical injury to Mr. Cranston, it could not reject self-defense on the basis that Mr. Cranston could have just walked away, which again is exactly what the prosecutor was suggesting the jury find.
Can you clarify the record? It seems like there was a whole bunch of things going on. It wasn't just 30 dead seconds where he was not deciding what to do. There was, first he hit Mr. Cranston, and then did he then hit Mr. Smith and push the girlfriend out of the way? Or
yes,
was that the order?
Yeah, the order is unprovoked. BW hits Mr. Cranston 2 times. Mr. Cranston is disoriented by that. His head feels fuzzy. He has experiences of serious physical injury at that point, pursuant to, again, the standard of review. Then BW hits Mr. Smith, his friend, also there. Mr. Cranston's fiance is, so concerned that she gets out her phone and starts filming like what is going on. And then BW pushes her and pushes the phone out of the way. And then as BW is attempting to swing again, Mr. Cranston does pull out his gun. And actually there is one important sort of thing in the middle, which is that Mr. Cranston does sort of brandish his firearm and sort of like look, this is really serious. I'm going to protect myself, sort of, putting BW on notice that deadly force is at issue. He does have a right to protect himself. And ultimately he does. And so for the jury to correctly decide self-defense and analyze the elements of that defense, it had to understand that Mr. Cranston had a right, and Sandoval says right, under Oregon law, to meet a threat of force with force. He did not have to walk away, which is exactly what the state suggested. I think, going back to Sandoval, one thing that I think the opinion makes very clear is that there is a necessity requirement in the self-defense statutes, and Sandoval takes that on directly. And Sandoval says that means that the jury has to evaluate the actual threat of force against the defendant, because what the legislature intended is that, again, when someone is facing a threat of serious physical injury or deadly force, they don't have to run through all the alternatives in this split-second determination. The jury's focus needs to be on defendant's belief as to the reasonableness of the threat of force against them, not on what other options were available. And that, I think, is the clear holding from Sandoval and what the legislature intended. The state relies on State versus Harriman, which we address in the reply brief. I think the facts, one thing to note about Harriman, the court never says that the lack of duty to retreat requested instruction in that case was erroneous under law, which I think is what the state is suggesting in this case. So I think that's an important takeaway from Harriman. But also in Harriman, ultimately the court held that the facts in that case did not create a risk of jury confusion. So this case is just distinguishable on the facts because of the evidence that the state presented, because of the state's decision to repeatedly question Mr. Cranston on the stand about if he could have just walked away. And then again, the prosecutor's decision to initiate, like bring back that idea, draw the jury's attention to it during closing argument. So again, this was a disputed issue in the case in a way that Harriman just wasn't. And so, in some cases, I think Harriman stands for the correct proposition of law that just giving the uniform instructions will be enough. But in a case like this, where the state has put at issue whether a defendant could have just walked away, there is a genuine risk of jury confusion. And that's why both the error is harmless and the trial court has to give the instruction. Unless the court has other questions, thank you.
May it please the court, good morning. Jonathan Schilt on behalf of the state, asking this court to affirm the trial court's judgment. So on the first assignment of error, I think we have a slight disagreement with defendant, and I don't know if the court can hear me. This is the first time I've been in the courtroom, and the speakers are weird. In this courtroom, in a while, the speakers are a little weird. We have a disagreement about how to interpret Sandoval, I think, and then certainly a disagreement how the jury would understand the proposed instruction. So let me start with Sandoval. It sounds like defendant agrees with the state's position that there is no duty to retreat only in situations where a defendant faces an imminent threat and has a reasonable belief that that threat is imminent and that the nature of that threat is of a particular degree. And I think, counsel read one quote from Sandoval. I think that probably what better captures it is when the court said that Oregon law does not require persons who reasonably believe that another person is about to use deadly force against them to calculate whether it is possible to retreat from that threat before they use deadly force in self-defense. And so the point is that when a person holds the requisite belief that there's an imminent threat of a certain degree, in that situation, the person has no duty to retreat. But what the court also recognized is in situations where there's not an imminent threat, or the defendant doesn't hold a reasonable belief that there's this imminent threat, then in fact the law does functionally impose a duty to retreat, because in that situation, a person cannot use deadly force. Their only lawful options are essentially to retreat or do something else. And that's what the footnote in Sandoval is all about. It says if a particular danger is not imminent, a person who wishes to escape criminal liability may well be required to avoid the danger rather than seek it out. But the only issue the court was considering in Sandoval was if a person who faces an imminent threat and holds the requisite reasonable belief, in that situation, do they have to run through the options of retreat? And that is not true. But in situations where a person doesn't face that imminent threat or they do not hold a reasonable belief, the law functionally does impose a duty to retreat. And so when you...
So it seems like this whole time, though, there's either an imminent self-defense problem or an imminent defense of others issue, because it seems like one of them was imminently going to be a victim during this whole period of time. How does the law analyze that?
Well, the state's argument here is not that the evidence would not support a legally correct instruction on duty to retreat. It is that this instruction as given is overly broad, because what it tells the jury is that a person can use deadly force in self-defense or in defense of another person in essentially all circumstances or at all times, not just when the person has the requisite reasonable belief that there's an imminent threat. And so that's what's lacking here with this instruction. And what the defendant says is, no, the jury would have understood by using the term self-defense that what's required is that that's a cross-reference to all of the other requirements of the self-defense instructions. But in fact, the jury instructions on self-defense say the defense of self-defense or defense of others has been raised. And so what the instruction effectively communicates to the jury is that there's no duty to retreat anytime a person raises the defense of self-defense, that you have no duty to retreat even if you're not facing an imminent threat, even if you don't hold a reasonable belief. But Sandoval says, no, actually there are situations, that is a situation where functionally a person would have to remove themselves from the encounter because their lawful option is not to use deadly force in that situation. And so for that reason, the instruction tells the jury too much in that it covers situations, it's too absolute, and it basically says, even in situations where there's a non-imminent threat, a person wouldn't have a requirement to remove themselves from the situation. And that is why this instruction is legally incorrect, or the court doesn't need to even say that. Is it reasonably capable of confusing or misleading the jury? And I think it is. Now, that doesn't mean that there couldn't be a correct instruction. The instruction would have to say a person who reasonably believes that another person is about to use unlawfully deadly physical force has no duty to consider whether it is possible to retreat. That reflects what Sandoval teaches. But when you have an absolute statement that there's no duty to retreat at all, whenever a person raises this defense or whenever a person uses deadly force in self-defense, that's where it runs the risk of misleading the jury.
What about the risk in this case of the jury being confused by the arguments presented by the prosecutor?
Well, so I think these are independent issues. So the first, if this is not a legally correct instruction proposed, or it's reasonably capable of misleading the jury, then the trial court didn't err by not giving it. But alternatively, even if it is a legally correct instruction, I think here that we've presented an alternative argument that the instructions given adequately convey the law to the jury. And so I think Harriman takes care of the idea that the instructions themselves would confuse the jury in believing or likely believing that there is some duty to retreat. Now, defendant's argument is that the prosecutor's questions, cross-examination, and in closing argument would have caused the jury to think that the law imposes a duty to retreat. And my position there, the state's position, is that if you look at the prosecutor's closing argument, the prosecutor was not making that point. The prosecutor was saying, look, this was not an imminent threat. Defendant didn't have a reasonable belief that this was imminent. There were 30 seconds that passed. And I understand this is an argument about how to interpret the evidence, but this was the state's position, that the threat was not imminent. So in that time, because the threat was imminent, defendant's lawful options, and the prosecutor uses the term lawful options, were to do something else, were to call 911, or to retreat from the situation. And that's a correct statement of law under Sandoval. What the prosecutor didn't convey is, even if defendant held the requisite reasonable belief and this was an imminent threat, he's still not lawfully justified in using self-defense because he had to consider, whether he could retreat safely. That's the distinction, that the prosecutor can point to defendant's other lawful options when saying, look, this was not a justified use of self-defense because this was not an imminent threat, or defendant didn't reasonably believe it to be an imminent threat. But the prosecutor can't go farther and say, well, even if it was, then the defendant didn't act in self-defense because he failed to retreat. That's where the no duty to retreat comes in.
The problem I'm having with that is I understand the separation of the two issues, but I think they do merge a little bit when you look at the trial court's rationale for denying the jury instruction, which was whether it was reasonable for Mr. Cranston in that situation under all of the circumstances not to have retreated, which I don't think is accurate. And I think it does sort of potentially echo the prosecutor's argument to the jury.
So I would disagree with you on the last point. On the trial court's ruling, so there's this extended back and forth. I agree it's difficult to parse. I think that parts of what the trial court said were legally incorrect if the trial court was suggesting that a failure of a duty to retreat can be considered if a person holds the reasonable belief that they need to use imminent force. That said, the ultimate ruling that the trial court made was that this instruction was covered by the other instructions, and then it wasn't necessary and likely to confuse the jury. That's what I'm defending. Some of the trial court's reasoning, I agree, depending on how you understand it, could be incorrect, but that's not a reason to reverse here because the ultimate ruling is correct, and because the trial court had no obligation to give an instruction that was legally incorrect or likely to mislead the jury. Now,
but given that the state had the burden of disproving self-defense, then they also have the burden to instruct the jury if there was an imminent threat on no duty to retreat?
I, I, I,
It's their job to make sure that the jury has all the instructions it needs, correct?
I would disagree that the state has any obligation, that when a defendant requests an improper instruction that incorrectly states the law, that the state has any duty to basically respond and provide a legally correct instruction. Certainly, what I would say is, unlike the cases where this court has reversed on plain air grounds because there's been some aspect of self-defense that's been missing, that all of the instructions on self-defense were given. And all defendant is saying is, well, there needs to be a clarification that not that there's another requirement of self-defense, that there isn't another requirement of self-defense. And so this is not a situation where the jury didn't have the necessary instructions on self-defense, like in some of those plain air cases where this court has, looked at whose burden it was to provide the instructions. So that's kind of what that brings to mind to me. And so I don't think in this particular situation where it's defendant's requested instruction that the state had any obligation to do anything more than it did, which is identified to the trial court that it should not give this instruction.
And so just to clarify, the problem with the jury instructions that defendant proposed, which is that Oregon law does not impose a duty to retreat before a person can use deadly force, is that it needed just more words to say in the event that it was not reasonable for them. I mean, what's the problem with the jury instruction?
The problem with the jury instruction is that it doesn't convey to the jury that a person has no duty to retreat only in situations when all the other requirements of self-defense are met. And that's all. And so if an instruction said a person who reasonably believes that another is about to use unlawful deadly physical force, if a person reasonably believes that person has no duty to consider whether it's possible to retreat. And what the instruction conveys is that
So duty to consider whether it's possible, I sort of see what you're saying with the reasonableness piece, but duty to retreat, is it the state's position that in some circumstances there is a duty to retreat?
Yes. In situations where a defendant has no reasonable belief that there's an imminent threat, so defendant cannot lawfully use deadly force. The only only lawful option, or one lawful option, is to retreat. And that's exactly what Sandoval says when it says a person who wishes to escape criminal liability may well be required to avoid the danger if the particular danger is not imminent.
And you disagree with the interpretation that that's referring to the initial
I
aggressor?
think that's not just referring to the initial aggressor instruction. That's one example of a situation where there could be a duty to retreat, but the court spoke more broadly to situations where the threat is not imminent. And in any situation where the threat is not imminent, so defendant is not justified in using deadly physical force, functionally, the law imposes on that person a duty to do something else. Their only lawful option is to do something else. And one of those things, as the court said in Sandoval, may well be to avoid the danger, to retreat. And so when you tell the jury that at no point when you use deadly force in self-defense that you don't have a duty to retreat, that speaks much more broadly than Sandoval, and it risks confusing the jury. I think that's ultimately the problem here.
Is that true, even though the facts that the judge heard arguably show that there was an imminent threat to somebody at all times during this altercation?
I think that the legal correctness of the instruction needs to be judged based on the face of the instruction. Does this correctly capture Oregon law? And again, I'm not saying that these facts don't support a legally correct instruction on no duty to retreat. I'm just saying that the instruction that was proposed doesn't accurately convey to the jury what Oregon law provides. And in this case, if the court says this is a legally correct instruction, then it's going to be a legally correct instruction in all cases. And that is the particular concern here, that this is a very nuanced and difficult issue to capture. And if it's not captured correctly and with the nuance that Sandoval requires, it can really mislead and confuse juries in this case and in future cases.
I see that you're almost out of time, and I just wanted to ask if you had any response to the arguments in the reply brief on the Chitwood issues.
So on the Chitwood issues, I think we fully covered the vouching question. I mean, I think the case law at the time of briefing, and it's been developed since, basically says that if the arguments are tied to the evidence, that the arguments about credibility are permissible. We've laid out in the brief why these arguments are tied to the evidence. And also this court needs to look at the context of those. The arguments as to, denigrating defense counsel or the other arguments, we think in context, those arguments are proper and were also grounded in the evidence. And to the extent that they weren't, that this is a case where a curative instruction easily could have addressed any problem. And I think this fits comfortably within this court's case law. The 40 or more cases where this court has said that particular comments that are claimed as improper can be cured with an instruction on plain error review. And I see that I'm out of my time. We ask that this court affirm. Thank you.
May it please the court. The state's position as to the self-defense instruction is that there is a duty to retreat if the person's not lawfully acting in self-defense. And that is not, in dispute. The reason why the instruction is needed is because the jury could draw the opposite inference. And, to Judge Kamen's question, the trial court did. The trial court made the same mistake that the jurors certainly reasonably could have made. And that mistake is that the jury could have said, okay, we find that the state failed to meet its burden to disprove the elements of self-defense beyond a reasonable doubt, including the imminence requirement. But defendant had other alternatives available. And again, that is the direct teaching of Sandoval. Sandoval says that there is a right to meet force with force in self-defense. There is no duty to retreat if the elements of self-defense are otherwise satisfied. And I think that is really the sticking point here. The state wants, in order for there to be an instruction, I guess, for all of the elements of self-defense to be restated in the requested instruction, that the requested instruction had to say, and don't forget, you still have to find imminence, and don't forget, you still have to find the defendant wasn't the initial aggressor. But of course, the jury's already instructed on all of those things.
But then what does that footnote in Sandoval mean?
Right, the footnote says that, I think exactly the point that defendant is making, that if there is no imminent threat, maybe there's a duty to retreat, there is no self-defense. So, potentially the jury could use the same evidence that we're talking about for the quote duty to retreat or not, like the amount of time, the 30 seconds, was it enough time to disprove, to try to say there was enough time to go to the imminence. But certainly, I think the risk and the reason why the instruction is needed is to clarify that if there is an imminent threat, then there is no duty to retreat, right? And the imminence is baked into the self-defense statutes. And the uniform instruction, which defendant requested and the trial court gave. So really, there's no question. Yeah.
There are other circumstances where the court has to hear predicate facts before it can give an instruction, right?
Yes, Your Honor.
Less satisfactory evidence, things like that.
Right.
So it would have to make some sort of prejudgment about whether there was an imminent threat to decide whether to give the duty to retreat instruction or not?
No, I think, the point, and I think actually Harriman does speak to this idea. The point is that the instruction is necessary when the uniform instructions are necessary to clarify a point of law that the uniform instructions don't otherwise require. And that will be, I think, to some extent based on the facts. It's, just this court's general standard for whether a requested instruction is required. There has to be a factual basis for it. And in this case, there was a factual basis for it, again, because of the prosecutor's questioning and argument. And, as the state says, potentially the jurors could have used it as to imminence. But the risk is that the jurors could have said there was an imminent risk of threat to Mr. Cranston. The state failed to disprove that, if it accepted defendant's testimony. But there were couldn't he just have walked away, which is the way that the state framed it. So that, again, is why the instruction was required in this case.
Do you have any follow-up to the argument that it was confusing or would have confused the jury, just in terms of how it was phrased?
No, I mean, the phrasing is clear and, succinct. It's Oregon law does not impose a duty to retreat before a person can use deadly force in self-defense or in defense of another person. So again, the instruction is saying there still has to be self-defense. The person has to actively be lawfully acting in self-defense in order for there to be no duty to retreat, right? That is the point of this. And
But it wasn't incomplete or
no, because we have the uniform instructions. I think, if this was
complemented
the
that and worked in
right.
conjunction with it.
defendant would not, it would be confusing if this was the only instruction that defendant was asking for, right? Saying like, look, the jury only needs to hear about duty to retreat. Of course not. The jury hears as an element of self-defense that the state has to disprove beyond a reasonable doubt that the threat was imminent. So that, I think, that answers the state's point in defendant's position. I see my time is up. Thank you.
The case is submitted and we're ready for our next case.